Thank you so much. Good evening, all. Can someone please confirm am I audible or not?
Yeah, madam, you are audible.
Thank you, Anup. Thank you so much. Good evening, all. This is Deepthi from Hemang Doshi Academy. Delighted to welcome you all to the commencement of GDPR Lead Implementer Certification Program, October 2025. Let me introduce our trainer for the program, Mr. Bilal Ahmed, a seasoned consultant and an auditor with over 15 years of extensive experience in IT security, cybersecurity, business continuity, and data protection. I hereby welcome Bilal sir and request you to take over, and happy learning to all the participants.
Thank you very much, Deepthi. Hello, everybody. Good evening. My name is Bilal, and I will be your instructor for this course. Let me share my screen. I need some acknowledgement that you are able to see my screen. My screen is visible.
Yes, it's visible now.
Okay. You are able to see what I am writing on the blackboard.
Yes.
Okay, perfect. Okay, good evening, everybody. As I said, my name is Bilal. I'll be the instructor for this course. This course is related to GDPR, which is the data protection regulation, general data protection regulation. It is related to data privacy and data protection. This being a regulation, this being the first regulation which has which has come into existence in 2018, and since then it has gained a lot of popularity and dominance over the entire globe, especially in the European states. So we will be looking for this course for next couple of weeks and next couple of days. Okay, so before we begin, can I have a brief introduction of not more than 5 to 10 seconds from each of you, so that I will be knowing what type of audience I am facing and how to frame this course and how to present the examples so that you will be able to understand the concept. Let us start with the alphabetical order.
Good evening. My name is Anup. I am from Kerala, India. Okay, I work as a system auditor in a small finance bank. Okay.
Okay.
So I'm working as an IS auditor for the past 5 years. Okay. Earlier I was working with an IT department of a bank.
Okay, great.
Hi, this is Asela here. So I'm joining from UAE, Dubai. So I'm also into IT audit in one internal audit department in one of the steam manufacturing company in UAE. Looking forward to have a great session with you, Bilal, and the team. Thank you.
Okay, great. Welcome to this course. Yes, please. Next one.
Thank you so much. My name is Fred Bosa. I am from Uganda. I'm happy to meet you, Mr. Bilal. I think I pursued an here in Uganda. It's a great pleasure to be here. Thank you.
Thank you. Thank you. You're most welcome.
Okay, my name is Ilarion Chidihezu. I'm an IT auditor. I'm joining from California. I have an audit experience, IT audit experience for like 7-8 years. Banking and internal control and audit experience and internal audit for about 8 years too. Thank you.
Thank you and welcome.
Hello, my name is Kweku Opoku. I'm joining from Ghana, and I'm an IT auditor with security background, and I'm trying to learn much on this journey with you.
Welcome.
Thank you.
Okay. So we have divided this course into 4 days. This will be a 4-day course, today and tomorrow, and the next week, Saturday and Sunday. So we will be covering these 4 modules, and the topics which are, we will be starting with what is the data protection regulation, GDPR, what are the key terms that are used within this GDPR regulation. Please note that GDPR is a regulation. GDPR is a regulation. It's a regulation. It's not a standard. It's a law. Okay, so it has different terms. It has technical terms which are very much used in implementation and in managing this regulation. So we will be looking at data subjects. What are the data subjects? What is private data? What is the controller? What is a processor? What is privacy policy? What is privacy notice? What is the consent? These are the terms. These are the terms which are used within the context of GDPR. Then we will see what is the applicability of GDPR, what are different core principles on which GDPR is revolving, what are data subjects and what are their rights, what are their powers which has been given by the data regulator, or you can say the controlling authority to data subjects, what are privacy policy, how to draft it according to the GDPR requirements, what is a customer consent in context with GDPR, what does consent mean, and how to take the consent from the data owner or the data subject, how to prepare the inventory of processing activities, which is very important. You also may have heard about something called as ROPA, which is record of processing activities, article number 30, which is talking about how to prepare the inventory of your business processing, which is injected with private data or PII or PHI. Day 2, we will be seeing how to conduct the data protection impact assessment. It's a kind of risk assessment. It's a risk assessment which is specifically done in context with the impact to the data subjects. If there are data subjects and if you are processing their personal data or personal health data, what are the risks that can emerge or that can arise and how to control them. We will look at data protection officer as a designation. We will see the concept of data protection default and design. What are GDPR fines? Because there are many instances where an organization is sanctioned for files. There are, low monetary files and high hefty fines as well. So we will be looking at those. We will be seeing what is the data breach and how GDPR is talking about how to how to manage that and how to notify different stakeholders. We will see data transfer requirements, how we are going to transfer data, which is PII or PHI, from European Union to outside and vice versa. Day 4, we will be covering the modules which will talk about data mapping and its inventory. We will talk about some technologies which are also called as PET, privacy enhancing technologies. These are technologies which will enhance or which will uplift or which will increase the capability of an organization to preserve the privacy and safeguard the PII, PHI. These are the technologies which will help organizations to preserve the privacy of personal data. How the automation is helping GDPR or organizations in order to automate their privacy program, and how you can do internal audit or how you can do auditing with respect to GDPR and with respect to other relevant standards, which is ISO 27701. In addition to that, we will have case studies. We will do different case studies in each module. And I suppose you might have received the data, these case study templates, which we will be solving in the due course of time. As I introduced in the beginning, myself, Bilal Ahmed, I am your GDPR trainer. I have around about 14 to 15 years of experience in cybersecurity, data protection, and business continuity. I am professionally doing consulting. I do auditing as well. And I also take courses for the people who are serious about data privacy or cybersecurity and want to take these fields as their profession, or want to enhance the skills and to uplift or upskill their capabilities in the organization. We will be taking a 30-minute break. It depends upon your perception, or it depends upon your timing, what time you want to take. It's a collective decision. We will take the break after your consent. Any questions so far?
I have a question, and my question is, what is the, I heard you say that GDPR is a regulation and not a standard. My question is that, is there any professional exam that is to be done to certify you as a GDPR implementer and that is recognized internationally? Thank you.
Now, as I said, GDPR is not a standard, it's a regulation or it's a law which is governed by a governed body, okay, which is governed by a regulator. So, the standard being the best practices, you can say ISO 27001 is a standard. ISO 22301 is a standard. So ISO standards 27001, which everybody knows, it's a world-renowned standard. It's a standard which is dealing with the information security, right? Information security. Or you can take another standard, which is 22301, which deals with the business continuity. You can take 9001 as quality assurance standard. Likewise, there are different standards. These standards are best practices. These are the best practices which an organization can use in order to enhance their capabilities of business processes or business resiliency. So these standards will help organizations in order to enhance their business resiliency and optimization. While as regulation like GDPR is an imposition or implication. It's an implication or a liability. You can say it's a liability, legal liability, legal compliance, legal liability on the organization. They have to, they must. Otherwise, they will not be able to operate within that part of the globe. Standard, it's up to the organization whether they want to take it, whether they want to implement it or not implement it. There is no fine if they will not implement ISO 27001 on the organization. There is no fine if they they are not certified for 22301 for the organization. But there could be liabilities or risks which are related to fines and sanctions which a regulatory body is imposing on the organization. That's why it is a regulation. It's a law that an organization must abide. Otherwise, it will not be able to operate within the region. Is this clear?
Yes, it is. Thank you. So if I want to practice as a privacy consultant, it's for me to look out to write the exam, the certification exam of 27001 or 9001 or the one of 22301. Is that the certification for to operate as a GDPR implementer?
After this course, you will be allowed to perform and do the exam, and if you pass that exam, you will be given a certificate. You will be given a certificate saying that you have attended the training and passed the exam, and you are having the knowledge and skill for GDPR, for implementing GDPR. So this will be done by the Hemang Doshi Academy. They will certify you because they are going to have the exam. You will be passing that exam, and after the passing, you will get this certificate. So this is an authentic certificate that assures that you have attended the training, and after the training, you have appeared in the exam, and that exam you have qualified and you are certified.
Thank you.
Okay. Any other questions? Okay. Now we will be talking about GDPR, and before talking about GDPR, we have to see what are the different terms. What are the different terms and definitions which will be used by this regulation? First is the data subject. Okay. Before talking about the terms and conditions, let me define the main stakeholders. Main stakeholders of GDPR. First is the data subject. Suppose this is Bilal. This guy is Bilal. And Bilal is having his personal information. What is his personal information? Name, first name, last name, email, mobile. Correct? So first is the data subject. This is the first stakeholder of GDPR. Any natural person, which is identified or who is identified with data, with personal data elements. Any natural person which is identified by the personal data elements. What are those elements? These are the elements. First name, second name, email, mobile, maybe postal address. If these elements combine, from 1 to 5, these are called data elements. If these combine, they will recognize a natural person. That natural person is called the data subject. So here, this data subject is a natural person. Example of data subject could be the individual, a customer, a prospect, an employee, or a contact person. Okay. Personal data, as I told you, personal data can be your first name, your last name, your email address, your mobile, your geolocation. These are all called data sets. These are all called data sets or data elements. If they combine, they will recognize Bilal uniquely. There can be thousands and hundreds and 100,000 Bilal in the world, but how can it uniquely represent me? How can it uniquely represent me? If these combine, more the data elements, more the possibility that I will be recognized uniquely. So the personal data, any information related to an identified individual, whether it is related to his private, professional, or public life, can be his name, email address, bank details, credit card number, social security number, medical information, IP address, which directly or indirectly identifies a person. So here I am being identified by these data elements. So these data elements are my personal data. Is this clear? Sensitive personal data. Now, personal information is divided into two formats. One is called PII, another is called PHI. This is called personal identified information. This is called personal health information. PHI is the subset of PII and it is called as sensitive PII, because it deals with the health information of an individual. If I am going to a doctor and doctor prescribes me some medical tests and I did some medical tests which is related to my blood sampling, okay, my X-ray, my CT scan, whatever information is contained in these tests is sensitive to me. That is called as PHI. So this will be categorized in the PHI category. So personal information, two types, PII and PHI. PHI always deals with the health information. Sensitive personal data, it is also called as This one is called as sensitive. Other form of sensitive information, sensitive PII, medical records, biometric, criminal records. They are all categorized as what? Sensitive information. Political views, sexual orientation, they are all called as sensitive PII. Are you with me? Hello, am I audible?
Yes, yes, you are.
So are you understanding what is a PII and what is a sensitive PII? Am I audible?
Sir, one doubt.
Yes, yes.
Sir, one doubt. Okay, Anup here. Sir, all PIIs are not
Yes,
sensitive, right?
yes. All PII
I mean,
are
all
not
PIIs are
sensitive.
sensitive.
Yeah,
Okay,
PII,
okay.
all
So
PII
it
are
is
not
depends
sensitive.
on. Okay. Whether it depends on country to country or it is common for all the countries.
No, it is common for either the PII would be personal information, or it will be sensitive personal information. So this is called PII and this is called PHI. There are only two types of PII, PHI. There are only two types of personal information. One is PII, another is PHI. PHI is subset of PII. Meaning if this is a set of PII, which is having first name, last name, email, then there would be another set here which has the information of PHI, which can be medical records, which can be biometric, so PHI is a subset of PII. PII is a big category. One small category in PII is PHI, which is dealing with sensitive information. What are those sensitive information? Medical records, biometric, criminal records, political views, sexual orientation. Clear?
Sir,
Now,
this
data control.
this, sir, one doubt, the political things, now you mentioned political views. But how the political
Right.
views are part of PHI? That is that is not health information, no?
If I am voting for a particular political party, okay, and in the election I am voting that particular party, is that information personal and sensitive? Because my vote can elect person or they can reject a person. When the voting is done, that information or that voting score is very critical or very sensitive. In that context, that information is categorized as sensitive information, because that can, that vote, once it is done collectively, it can form a government of a country. Are you understanding my point? Is this clear? Hello? Am I audible? Hello?
Yes, we can hear Bilal.
Okay, now the data controller. Data controller is an organization which collects the PII, PHI. Okay, it is an organization or entity which collects information from data subjects. Okay, so organization which collects information from the data subjects is called controller. What it is called? Controller. Example of a controller, bank. What is the other example? Internet service provider. It can be another example. What is the other example of a controller? Hospitals. What else? Insurance companies. Are you with me?
University.
Yeah, educational institutions, which include schools, colleges, and universities. So all these entities are collecting PII from data subjects. Any entity, these are all entities. These are all entities. Or you can say companies, or you can say institutions. They are collecting information from data subjects. That they are called controllers. Then this collection of PII is being processed by controller. They are controlling this processing. PII is getting processing. And who is the decision maker of the processing? How, when, where, which, all these are decided by the controller who is collecting this information. So this is a very important stakeholder of the GDPR, controller, because he decides how the processing will be done, when the processing will be done, where it will be done, and which data it will be done. I mean, which PII it will be done. Okay. This is controller. Data processor. Now, this is the controller. We have another entity which is called as processor. Processor. Data processor. What is his task? Processing of PII collected by, who is collecting? Controller.
Controller.
Example. This hospital.
Controller. Banks, hospitals.
Yeah. This bank, for example, this bank is outsourcing HR department. They are outsourcing HR department to a company which is called as XYZ HR, which is in India or which is in Africa. They are managing human resource for bank. Their payroll, their human resource, their onboarding, offboarding, their recruitment, everything of this bank is outsourced to a company which is called XYZ. Then XYZ is called as a data processor in the context of GDPR. They are processing. This bank is having, say, 10,000 employees. All that 10,000 employees data is with XYZ. Why? Because they have to manage their salaries, manage their increments, manage their attendance, manage their health insurance. So this is called processor. Are you with me? Are there any questions? What is the next thing? DPO. DPO, Data Protection Officer. Data Protection Officer. This is the guy who is responsible. This is the guy who is responsible, or the designation who is responsible for data protection program for this bank, for this internet service provider, for the hospital, for the insurance company, for educational institutions, or for any entity who is implementing GDPR. So this is the person who is responsible for managing this program within the organization. It is a designation which is having this responsibility, who is assigned this task to manage end-to-end data protection program, end-to-end GDPR. Is controlled or managed or run by this DPO. Accountability. What is accountability? Before that, let me introduce you to our dummy company, which is ABC Retail. Are you seeing my screen?
Yes.
Yes, sir. Yes.
Yeah, this is a dummy company. We will be taking the reference of this dummy company. If you can see, there are different levels. This level is for leadership. There is one designation which is not, this is a DPO. This is a DPO. It has its own team that is called data protection team. We have departments, HR, procurement, marketing, finance, sales, IT. We have internal audit. We have the leadership in the form of board of directors and CEO. So it's a typical example of an organization who wants to implement GDPR. We had to implement GDPR in this organization. You as a DPO are designated to implement GDPR in the ABC Retail, and ABC Retail is operating in European Union. So this reference company, we will be framing our different activities of this course with respect to this organization. It becomes easy for us, and you will understand it from the implementation perspective. That is the main aim or objective of this course, that you should be able to at least implement this GDPR within your organization, or based on your location in the globe, whatever regulation, whatever data protection regulation you are following, you should be able to implement it. Okay. So now if you are a DPO, consider you are a DPO and you are here designated with a team. You have a team, data protection team, and you have been appointed to implement GDPR. So you are directly reporting. This dotted line is saying that you are reporting to leadership. Okay, and you have these departments where you have to implement GDPR or data protection program. Each department, if you can see, has inventory of data. That means what? This being a retail industry, this is a retail industry, it is selling. What it is selling? It is selling food, non-food, electronic, goods and items in their stores and online in the e-commerce. So they have customers and they are collecting the information from the customers, which is PII. And they have HR department also, which is collecting the information from all the employees, including CEO, including DPO, including, their families also, because they are providing the benefits, which are, one of the benefits could be the health insurance. So it will be applicable to you, and you have to get information for your family, PII of your family, so that you will avail that benefit from ABC Retail. Are you with me?
Yes, sir.
Yes,
Okay.
sir.
So inventory of the data, when you say inventory of the data, you have business processes within each department. Correct? Now consider HR. What could be the business process of the HR?
Recruitment.
Can I say recruitment?
Yes.
Okay. Can I say onboarding?
Leave management.
Can I say payroll?
No.
Background verification.
And can I, yeah, that will come under onboarding. Okay.
Performance management.
Performance management, yes. Okay, termination, training, okay. Now these are the business processes of HR department. From these 1 to 6, do you see that they have to collect personal information from the employees?
Sure.
Yes, it is but obvious, and it is clear that when they are recruiting people, they are collecting their personal information in the form of their resume, in the form of their first name and last name, in the form of their mobile number and email addresses. When they are onboarding the talent who are selected, they will ask their qualification information, certifications, previous background checks, clearance reports, police reports in some instances, okay, passport, social security number. In India, they might ask for Aadhaar card, okay. So all these processes are using or processing PII, agreed, including payroll. Payroll have the extra information. Maybe you have to give your bank details also, bank number, account number, and other information related to bank, because then only they will be able to process your salary. So what does that mean? What does that mean? That means HR, very important, HR department or any department which has business processes. These business processes are being injected by the personal information. They are injected or they are using personal information. What is the personal information for recruitment? First name of the candidate, last name of the candidate,
Phone number, email address,
cell number or phone number, email, maybe qualification.
national ID
Correct.
number.
National ID number. This is the minimum information that HR is collecting. HR is collecting. Now, when you say collecting, what does that mean? That means ABC retail is what?
Controller.
Is a controller. So PII, very important. PII is bound to business processes. So whenever you have to see what is the PII being used, you have to refer to business processes. You have to go back to the department and ask them what are their business processes so that you can identify what is the PII or PHI being used. We are dealing with retail, so we are only dealing with PII. If we had to deal with insurance, we had to deal with PII and PHI. Depends upon the industry, depends upon the type of the work that they are doing. What is accountability now? Accountability is that the leadership of ABC Retail is responsible for securing the PII collected from their customers. That's why they have recruited a guy which is DPO. That is the accountability. That means they are taking the responsibility that whatever PII, PHI is being taken by them from their customers, they are responsible for securing that by implementing or by adapting all the articles of GDPR. Okay, that is called accountability. This one, it is the responsibility of the company's leadership to do a due diligence. Due diligence means what?
Doing the right thing at the correct time.
Yeah, act responsibly. They are acting responsibly, meaning when the DPO is telling them that you have to implement data encryption in order to protect the PII, PHI, they are saying, okay, we are going to approve this budget for encrypting our PII, which is stored in the cloud or which is stored in the on-prem. Okay, so that is the accountability of the leadership, that they are responsibly acting for implementing all the articles or all the requirements and best practices of GDPR. Okay, privacy impact assessment. Privacy impact assessment is the type of the risk assessment. It's the type of the risk assessment that is done by the controller in order to recognize or in order to identify the risks which can encounter or which can materialize if they are not applying the necessary controls. Okay, this is a kind of the risk assessment. We will have a case study on this. For now, you have to know that this is a kind of the risk assessment which is done for identifying the risk against the freedom and rights of the data subjects. Processing means what? Any modification of the data which is happening within the controller or processor is called processing. It can be creation, it can be collection, it can be storage, it can be access of that information, it can be transfer of that information, or it can be deletion. Who knows about the data life cycle? We have data. There is a life cycle associated with this data. Can anybody tell me what is the life cycle that is associated with this data?
Collection.
Creation.
Creation.
Okay, creation of the data. Usage, or you can say modification. You are using that data now. First, you created that data. You are using that data. Then
Processing.
share or transfer the data. And then deletion of the data. So this is the life cycle of a typical data. Now this data can be your PII, it can be your PHI, it can be your business critical data, any data. But we are focused on PII, PHI. So it has a life cycle. So creation, you are creating, for example, you are creating a file, a Word file. Okay. Now, after creating it, you are filling that with PII and PHI. That means you are modifying that data. You are using that data. Now you are transferring it to your processor, to the third party for further processing. After that, they are again transferring it back to you, and after that, you are deleting it. Okay. So this is a normal life cycle of any data. Okay. So creation, usage or modification, or sharing and transfer and deletion. There are best practices or controls which are used at each stage of creation, usage, sharing, and deletion. There are best practices within GDPR. Within GDPR articles, there are best practices how to secure the PII, PHI during creation, during usage, during transfer, and during the deletion. Okay. That best practices are what we are going to learn. Okay. That is called processing. Profiling is a special type of automated processing which can predict what? Which can predict trends and behavior. Suppose this ABC Retail wants to do profiling of the customers and categorize them with the age group, or with their with the category of males and females and children and old age, and see what is their shopping trends. And after that, they are seeing the shopping trends and the behavior or the habits of the shopping. They want to understand which time of the year they are shopping, in order to give them the best experience. They want to have, or they want to make sure that they launch the promotions of their items and goods after seeing the trends and behaviors of their customers. That is called profiling. Are you with me?
Yes, sir.
Sir.
Okay. This is a special type of processing which is done by organizations for business intelligence, so that they can take business decisions, how to frame their, or how to present their items and goods to the customers. Okay. Consent. Now consent, how you can define a consent? Suppose Bilal is a data subject. It's a data subject. And Bilal needs internet. Bilal goes to an internet service provider and asks him that I need your services of internet. They are telling Bilal that we will give you 2 Gbps internet per month at the rate of $50 per month. And I need your first name, last name, email, and postal address. What they need: first name, last name, email, and postal address, correct? They wrote a contract. They wrote a contract that they will get 2 Gbps, Bilal will get 2 Gbps at the rate of $50 per month, and that is what they are going to exchange: first name, last name, email address, and postal address for billing. They will bill them every month, and these are the information that is needed from ISP XYZ so that they can provide him internet services. If this ISP is sending Bilal from now onwards marketing messages or any promotional messages, then they have to get the consent from the Bilal. Consent from Bilal that I am going to send you marketing messages or promotional messages. If Bilal has said yes, you can send me, they can send. If he has said no, they cannot send. This is the consent. This is what consent means. When they are deviating from the contract, in the contract they are saying they will use this information only for billing. This is only for billing. And if they are sending marketing messages and promotional messages, then they need to have this consent. That's what GDPR is saying. GDPR is saying if the data subject is having a contract, initial agreement, that my PII will be used for particular service, then if additional marketing messages or promotional messages or any other activity, the controller is using that information, then they have to get the consent from the data subject. This is what consent means. Explicit permission. Consent is an explicit permission given by the data subject for collecting, processing, or storaging of PII. Clear? Now this is the reference of this is the reference for the ABC retail, as I was telling you. So we have to keep this thing in mind. Now, what is a GDPR? GDPR is a regulation or a set of rules that defines how the processing, that defines the guidelines of how the processing of the personal information of the natural person, which is also called data subject, will be taking place or will be executed by an organization who is collecting the PII or PHI from the data subjects. GDPR is laying down the guidelines for companies which are expected to collect the PII, PHI from the data subject and use that PII, PHI in their business processes. So GDPR is telling them what are the best practices according to this regulation, according to this law, in order to secure the privacy, which is also called as a birthright of a natural person. So how to preserve that privacy, how to protect that privacy with the help of the process controls, with the help of the people control, with the help of the technological control, and with the help of the legal controls. Those all controls or best practices are being formulated in the articles of GDPR. Clear? Now, one of the important thing is applicability of GDPR. Where does the GDPR apply? There is a lot of confusion about applicability of the GDPR. First requirement is ABC retail, for example, is inside the European Union. The territory is within the European Union. This is the first requirement. That if the organization is within the European Union and it is processing the PII or PHI of the European Union citizens, then it is applicable to GDPR. Requirement 2 is if the organization or the entity is outside European Union, but it is processing the PII, PHI of European citizens, then also the entity or the organization is applicable to GDPR. So it does not matter. It does not matter if the organization is within European Union or outside European Union. What matters is if the organization is processing the PII or PHI of European Union citizens. An example is if the organization ABC Retail is operating in European Union and they are outsourcing their HR department to a company in India, then that company in India is liable to apply GDPR because it is processing the PII of European Union citizens. Okay. Are you with me? Are there any questions?
Sir, one doubt. Sir, this is clear. One doubt actually. Suppose that European Union citizen is not residing in Europe or in the territory of Europe, whether it is applicable?
If the citizen is not residing in European,
citizen of Europe, okay, but he is not residing there. Suppose he is in America or India, okay, whether any problem is the processing his data? Is it
no,
applicable?
if that is that in that use case, in that scenario, if that individual is having the nationality or citizenship of European Union, then of course it will be applicable. It depends upon that scenario where that individual is. Suppose he is born and brought up in European Union and now he has migrated to US, for example, or he is migrated to Australia or any other continent, okay, and his existing European, he is a national, he is a citizen of European Union, that still remains. If he has some transactions which he is still doing in Europe or European states, and if that transactions or if his PII is being processed by any of the entity in European Union, then of course it is applicable to GDPR. If there is no transactions, if there is no processing, no collection happening for that individual in European Union states, then of course it is not, he is not part of the GDPR, right?
Okay. Okay.
Okay, so when it is applicable, I explained you both the scenarios, requirement 1 and requirement 2. These both requirements will be applicable when you have to consider the GDPR applicability. Okay. What it will stress on? It will stress on data subject access rights. What are those data subject access rights? Data subject access rights are the, you can say this is the powers of data subjects. Because data subjects are what? If I am the data subject and I am sharing my PII or PHI, I am the data owner. Data owner. I should know where my data is, how it is processed, why it is processed, when it is processed, how it is shared, and how it is deleted. All this information I should be able to know. It is my right that as a data owner, I should know all these why, how, what, and who will provide me this information. Who will provide me this information? Who is collecting my data?
Controller.
I gave you example of an ISP. ISP is giving me internet connection. Correct? And in return, he is getting my PII. Now he is getting my PII. That means he should be able to answer all these questions. Where it is processed, how it is processed, why it is processed, when it is processed, where it is shared, with whom it is shared, why it is being shared. Okay, what are the different controls or different security measures that are applied, with whom, what is the name of the third party that I am sharing. All this information should be known to me because I am the owner. And later we will see how it is being presented. All these questions are answered by a document that is called as privacy notice. So GDPR helps to protect the rights of data subjects. There are 8 rights of data subjects. We will see what are those. It protects the freedom and rights of the European Union citizen. Okay, protection of the freedom and rights which has been given by the regulatory authority. Privacy is the right of an individual, and that privacy should be protected, should be preserved by the controller or the processor of PII and PHI. It is their responsibility. We have learned about accountability. What is that accountability? That is the responsibility of an organization's leadership to protect the freedom and rights of the individuals from which they are collecting the PII, PHI. It will stress on how you are transferring the data. As I told you, European Union citizen ABC Retail is operating in European Union, but they are outsourcing what? Outsourcing HR function. HR function is being outsourced to India, Indian company. Now, this information, PII, is being transferred from one country to another country. How how it is transferred, and what are the controls, what are controls and safeguards applied on the transfer of the data. That is being dictated, that is being explained, that is being taught by GDPR's transfer control mechanisms. Power of the supervisory authority. What does that mean? If any controller within the European Union are not following or having non-compliance NCs related to GDPR, then the power of the supervisory authority will come into existence and they will be sanctioned or penalized depending upon the non-compliance. Enable free movement of the PII across European states. Now, European states are freely exchanging PII. Why? Because they know each state in European Union is following. What are they following? GDPR principles. That means any entity which is in European Union knows that the other entity which I am transferring the data is having the safeguards and controls mentioned by GDPR. They are implementing it. It is safe to do business with them. It is safe to transfer PII with them. It applies to all the countries in the world who are processing European Union citizens' data. That means GDPR is not dependent upon the location of the entity within European Union. It can be any part of the globe where the company is processing European Union citizen data, and it is applicable to GDPR. Now, GDPR has given rise. Yes.
I'm sorry, one doubt regarding this. Sir,
yes.
Suppose a European Union citizen, okay, and his data, okay, suppose through online, okay, through internet, okay, he shared some data to an Indian company, okay. Indian company is not registered in Europe, okay, that's a pure Indian company, suppose. How they can enforce this GDPR on this Indian company? Because Indian companies are working on Indian regulations. Okay.
No. Who shared the data? Who shared the data?
European citizen shared his data. Okay.
Okay. If European
the server
citizen,
hosted by an Indian company, okay, which is hosted in India.
No. If European citizen is involved, he is the owner.
Yeah.
So
but the company is not registered in Europe. Company is registered in India. The company don't have any dealing with Europe. Okay? It's a pure Indian company.
Okay.
But he shared his data for some purpose, for some any online games or anything. Okay.
Okay.
How this Indian company is responsible for this GDPR? In that scenario, because they cannot enforce anything on Indian company now, because it's a separate rule. We have our own regulations. Right?
No, first thing is, as I see to it, this person who is the European citizen, he is sharing data to Indian company. Correct? Now, if his data is getting compromised, if his PII or PHI with Indian company is getting compromised, okay. First thing is that GDPR restrictions. Then it is a case of cross-border transfer. Now, this cross-border transfer has not happened with the controller. There is no controller involved here. No controller.
Right. Directly shared. Right.
It's a directly shared by the owner. Right? Now, if this
Correct.
is compromised, he is wholly and solely responsible for this compromise, because he cannot go to regulatory authority and say, okay, my data is being compromised, it is being breached. Can you apply the sanction or fines on this Indian company which I have shared data with? And then the regulatory authority will come back to that person and say that you have to have some other party, which is the controller or processor, with in between, so that we can see that the data transfer is happening with the respective controls from one entity to the other entity in another country. Since that is not the scenario here, he cannot. First thing is, he cannot go to the regulatory authority and he cannot apply the complaint against this Indian company. It is his own will that he has to do own due diligence and due care, how he is transferring data and how much this Indian company is capable to protect his PII, PHI, what are his controls, because that thing is done by the controller. Controller has a liability to check if this Indian company is having the appropriate controls, so that I can transfer data PII, PHI to this Indian company. And if that is the case, if this PII, PHI is compromised, the responsibility is on the controller. But in this case, in this scenario which you are saying, here no controller is involved. It is directly from the consent of the data owner or the data subject, that he is sharing that information to the third party.
Okay, so in this scenario, the European country, as such, they cannot ensure that protection of his data, right?
Yes, he cannot, because right now the entity is not involved. Who will have the controls and who will have the contractual, you can say, contractual requirements between company in European Union and company in India. If that is the case, if there is anything that the owner has signed with that company, a kind of a contractual agreement or something like that, then there is a different scenario. Then there is a contractual agreement between this company and the owner. Then he can take that contractual requirement and contractual document and go to the court of law or to the regulation and file a case against this Indian company. If there is no contractual requirement and he has shared the data based on his own will and without any control, then there is no such case, that there is no such thing that he can raise a complaint or this Indian company is accountable. It becomes accountable when there is a control, which is in this case is the contractual requirement between this citizen and the Indian company.
Okay.
Hello, Bilal.
Yes, please.
So I have a scenario.
Okay.
So you have a mad
Sorry, your voice is breaking.
So once you have a mother company in EU, a mother company eating and hello.
I'm not able to understand because your voice is breaking.
We are also not able to hear. Voice issues there.
Hello. Okay. So is this okay? Is this understood? All these points?
Sir, my doubt was that last point. Okay, it is applied to all companies across the world.
Yes,
To
sir.
process personal data of European citizens. That's the trouble. That's what I asked this question.
Yeah, it will apply to all the companies, meaning if the company is in India and the company from European Union, I gave you this example. If the European Union company, okay, is sharing the data, this is a controller, and it is sharing data with Indian company, okay, which is a processor.
Okay. Controller giving to processor. Okay.
Yeah, it is showing, it is sharing the data with the processor. Then this processor will be liable for GDPR.
Okay. So processor is also liable, not only controller.
Yes,
Okay.
but processor will be having less liability
Okay.
or less controls to apply. Controller has more responsibility, more controls, to apply.
Okay. Thank you.
Now we have GDPR, and there is another ISO requirement, or you can say another ISO standard, which is equivalent to GDPR. GDPR was laid down in 2018, May 2018. It came into existence. Then the ISO also launched a standard in 2019, which is an extension of what? ISO 27001. It has almost all the requirements of GDPR, meaning it is also defining the role, regulation. It is also defining the controls which will be applied on the controller while they are processing, collecting, processing, transferring, and deleting the PII, PHI of the data subjects. Okay. So in summary, when you are implementing GDPR, you can implement integrated approach of ISO 27701 and GDPR, because like 85 to 90% of the requirements are same. Okay, so 27701 is the requirements for the, it is also called as privacy management system. PIMS, Privacy Information Management System. So if you want to get certified, you can get certified for this control, but you should have already certified for, you should be already certified for 27001. That means ISMS. You should be having ISMS in place.
So
Are
this
you
is
with
for
me?
the company. This is for the companies. The company which is already certified for 27001 ISMS, they go for 27701 equivalent to
Yes.
GDPR. Correct.
Since April 2024, PIMS was dependent on ISO 27001. From April 24 onwards, ISO 27701 is an independent standard. Meaning what? Meaning companies cannot get certified for 27701 before April 2024. They should have 27001 already in place. But after April 2024, PIMS became an independent standard. Meaning what? Companies can directly implement and get certified for ISO 27701, which is the privacy standard, privacy requirements. Earlier, you should have, for example, ABC Retail wants to implement GDPR and ISO 27701 and get certified for this 27701. They cannot do it unless and until they are already 27001 certified. Then they can go to 27701 certification, which is PIMS. This is ISMS. Now it is totally independent. This dependency is not there anymore. Companies can directly go to PIMS without having ISO 27001 in place. Are you with me? Are you understanding my point?
Yes.
Now we have a quiz time. European Union GDPR applies to personal data of data subject who can be dash.
All of the above.
All of the above, because PII is collected from employee, PII is collected from the customer, PII is collected from the supplier as well. So all can be data subject, employee, customer, and supplier. As a part of implementing GDPR, it is good idea to refer to other frameworks like 29100. This 29100 is the supporting document or the standard for 27701, which talks about technology of privacy information management system.
Maybe true.
True.
So it is true. Okay. Select the right description of the controller. Now we saw what is the controller. Who is the controller? Okay. Why it is called as a controller? We also discussed about that. So first choice is organization that processes personal data, organization that decides the purpose of processing personal data.
Two.
First one.
Two.
It is the second, because as the controller, as you see, the word controller is derived from control. So they are controlling the processing. Who is controlling the processing? The controller.
Organized.
The controller. The controller are controlling how the processing will be done and decide who will do the processing. Either they will do it in-house or they will outsource it. It is totally up to the controller whether they want to do the processing in-house. In our case, we have internal HR department. ABC Retail has their own HR department. Or they can outsource the HR department to the other organization. Totally depends upon the controller. Clear? Now, we have explained these. I think this is already we discussed about what is the role of the controller. Role of the controller is to decide how the processing will take place. Okay, and they will take actions against the data which is being collected from the data subjects. And role of the controller is to abide all the rules of the supervisory authority and also the powers of the data subjects which has been assigned by GDPR. That means the controller has to do what? They have to abide all requirements of GDPR. Role of the processor, they have to do the processing according to the instructions of yes, please. What is the role of the processor?
Processing the data shared by
Sure. Yeah, processing the data according to the instructions of the controller. And how they will decide the instructions? With the help of
agreement.
Data processing agreements. I told you, I explained you the scenario, this one, where we discussed about the individual sharing data with the Indian company. If he has data processing agreements or the contract, then he can go to the court of law. If he doesn't have this one, he is paralyzed. He cannot do anything. Same goes for the controller and processor relationship. Okay, there is a controller who is telling a processor how to process what? PII or PHI. And this is documented where? In the data processing agreements. Data processing agreements are the documents or the contracts which is being signed by both parties. Controller and processor. They agree on how to do this processing. what is the responsibility of processor, what is the responsibility of the controller, who will be liable for doing what controls he will apply, what controls processor will apply. Okay, so all that is defined in an agreement that is called as data processing agreement. And this data processing agreement is also a requirement of GDPR. GDPR is saying that if the controller is giving instructions to the processor to process the PII, PHI, then there should be a agreement. That is called data processing agreement or data protection addendum, also called as data protection addendum. Are you with me?
Yes.
Okay, so this will decide. If this is not there in place, then all the fines and the controller will be liable for regulatory fines. It's a non-conformity. Role of data protection officer. What is the role of data protection officer? Data protection officer is responsible for the DPO is responsible for all the management, enforcement, measurement, implementation, and implementation of GDPR. He has to manage the data protection program. He has to enforce it with the help of the policies, procedures, and guidelines. He has to measure data protection program. He has to implement it within the organization. Okay, and he has to, he has to improve. He has to improve this.
Excuse me, sir.
Yeah.
You had told us that we shall take a break
Yes.
for about 30 minutes.
Okay, after this slide,
I'm
we will take
suggesting we
it.
take.
Yeah. This is the slide
Yeah.
after that.
Okay.
Okay. Role of the supervisory authority. Role of the supervisory authority is, who is the supervisory authority? The one who is overseeing or governing GDPR regulation over the states of European Union. A body who is governing the regulations, who is doing what? The governing body or the overseeing authority or the ultimate authority or regulatory authority, okay, whatever you want to call, that body or that organization who is overseeing from the top against the improvement, against the modification, against the awareness, against the non-conformities of GDPR, that is the responsibility of the regulatory body. Okay. We will take a break. Let us take a break for 30 minutes and we will be back.
Thank you, sir.
Okay, can we start now?
Sure, sir.
Okay. So there are some supervisory authorities which are governing the different data protection laws and regulations within different countries. For United Kingdom, it is the ICO, also called as Information Commission's Office. Information Commissioner's Office, which is the regulatory body for governing the GDPR. In India, it is Data Protection Authority of India. UAE is the UAE Data Office, and in KSA, Saudi Arabia, it's Sadaya and NDMO. Some myths about GDPR is it is applicable to European Union only. GDPR is about consent from the data subjects. It is only about.
You are not sharing.
Sorry?
You are not sharing.
Oh, okay. My screen is visible?
Yes.
Okay. So these are the different supervisory authorities. As I told you, for United Kingdom, it is Information Commissioner's Office. For India, it's Data Protection Authority of India. UAE, it's UAE Data Office. For KSA, it's NDMO and Sadaya. There are some myths related to GDPR, which is it is applicable to European Union only, while we discussed that it is applicable to any entity who is processing the PII, PHI of the European citizens. It is only about the consent. Data subjects has to give the consent, and that's what it is in GDPR. It is more than the consent. It is different principles of the GDPR which need to be applied, or which the safeguards of different requirements of the GDPR need to be applied within the organization. It is only about the fines. GDPR is only about the fines, but it is not the case. It is not about the fines. It is also about enhancement, or you can say improvement, of the data protection program within an organization. Regulatory authorities are not only there to impose fines. They are about to spread the awareness. They are about to enhance the culture. They are there to listen to the grievances of the data subjects and direct the controllers and processors in order to correct them for those mistakes and those non-conformities. And last but not least, it is there to improve the regulation itself. Okay, because every time there is new technology and new enhancement with the help of AI, with the help of digital transformation, or with the enhancement of the technology itself, the regulatory authority are the one who will dictate or update the regulation according to the different new technologies which are coming into existence. For example, AI. Now the adoption of AI by the organizations will change the perspective of the data privacy, and it will affect and have a very large impact on the processing of the PII. How the AI is going to use the personal information and how the AI is going to treat that. Is it treating it in a safer manner, or is it is compromising the privacy? Those things need to be thoroughly discussed and implemented by the regulatory authority. all organizations need DPO. It is not the case. It depends upon the size of the organization. It depends upon the structure, the organization structure, the hierarchy of the organization, and it depends upon the volume of the PII or PHI which is processed by the organization. So it does not mean that if you are implementing GDPR, you have to designate one DPO. Okay, you can have the DPO as any other person or you can designate any other person within the organization to manage your data privacy or GDPR program. Okay, but if your organization is a big organization, it is processing high volumes of PII, PHI, and if you have the hierarchy, the organization structure is vast and complex, then of course it needs a data protection officer. These are the different activities by which the GDPR is, when GDPR is introduced in an organization. As we know, we have an ABC Retail as the reference organization. So ABC Retail has HR a department which is getting impacted by GDPR implementation. How it is getting impacted? Because the business processes, as I told you, business processes within the department decide that what type of PII, PHI is getting processed. So if the HR is processing the employee data, that HR department need to align those business processes, align it with, yes please, GDPR requirements. We have seen the example of recruitment, right?
Yes.
Are you understanding what I am trying to say? We had different
Yes, sir.
departments. We have different departments. For example, HR, marketing, IT, finance, okay, then sales, then procurement. All these are processing PII, PHI, okay, and all the departments will have to adapt for GDPR requirements. What does that mean? That means HR business processes, if it is recruitment, if it is payroll, or if it is onboarding, all these business processes will be in line with requirements of GDPR. That means whatever GDPR is asking for HR department, because these departments belong to ABC Retail Company. Okay, these are different departments. So these department has to align its business processes with GDPR. For example, we will take an example of HR, and you will see after that you will be able to map it to the other department as well. Recruitment. Recruitment process. What is the PII being collected? First name, last name, email, postal address, national ID, and CV and certificates. What is GDPR saying? That it should be legal activity. Legitimate purpose. When you are collecting this personal information, it should be legitimate activity. It's a legal activity. Is it the legal activity? Is this the legal activity? Is recruitment a legal activity? Yes or no?
Yes.
Yes, it
Yes,
is.
yes.
So yes, data minimization. GDPR is saying when you are collecting data for any business process, it should be minimal according to the purpose limitation. So ABC Retail has to implement the principle of data minimization while collecting PII for the recruitment. So yes for data minimization. Purpose limitation. This is another requirement for GDPR. What is purpose limitation? That this recruitment process is collecting this PII. This will be only used for recruitment and nothing else. Meaning they will not keep it and they will not sell this information. That is called purpose limitation. Only to the purpose for which it is collected. It is collected for recruitment, that this personal data is used in order to process the candidates by ABC Retail. Once the shortlisting is done, they are going to delete this information. So purpose limitation, yes. Then consent management. If they are using it for another purpose, maybe they are using it for business intelligence, this recruitment PII, if they have collected it and they are keeping it and using it for profiling or error processing or selling it to the third party, then they should get a consent from the candidates. So yes for consent if they are violating purpose limitation. What is the purpose limitation? It is one of the principles of the GDPR. Purpose limitation is one of the principles of GDPR. We will see the principles that it is only used, it is only meant for that business process, only meant for that purpose. So you can see that there are different requirements. Then there is, if the purpose is set, then deletion or retention. They are going to decide how much time they are keeping this information, and after that, when the purpose is done, they are going to delete it. So yes for this also. So you are seeing this recruitment process is being undertaken by different requirements of GDPR. These are all the requirements of, they are what? These are all requirements of GDPR. and the recruitment process is following it at different stages of data life cycle. What is the data life cycle? Collection, processing, sharing,
deletion,
transferring, and then deletion. So different life cycle of data is having different controls from GDPR. That means HR department, marketing department, IT department, finance department, sales department, procurement department, all departments are affected by GDPR. All departments has to apply these principles or these requirements of GDPR at different stages of processing. This is all processing. 1, 2, 3, 4, 5. This is all called stages of processing. Likewise, the recruitment business process is affected. Payroll is also affected. The ABC retail HR department will not ask me my maternal status for my salary, for my payroll process. They will not ask me about my family status for processing the payroll, because that is irrelevant. And they will be violating. If they will ask me more questions or more data, they will be violating what? Data minimization principle. Are you with me?
yes, sir.
So different stages or different departments of the organization is getting affected. For example, marketing department, they need to recognize whom to send email, marketing email, and whom not to send. If they have given the consent, they can send this email, marketing email. If there is no consent, they cannot send the marketing emails to their customers. IT department need to make sure that they have the necessary controls in the IT systems so that the privacy principles are applied. Okay, for example, encryption, masking, access control, okay, multi-factor authentication, identity access management, where they will control need to know and least privileges, because they are very important controls for maintaining the privacy. Likewise, procurement need to deal with the suppliers, so they need to talk to them in the contractual language, that if you are accessing the PII or PHI, or we are sharing this information with you, how you are going to handle it. The teams of each department need to be educated or made aware. That is why the DPO is having responsibility for awareness and training. Now you can see all the departments are involved. All the departments are involved in GDPR, correct? Now they all need what? Training and awareness. Training and awareness need to be given to HR, how they can implement data minimization, what is purpose limitation, how they can take consent, how they have to delete and maintain retention policies. Same goes for the marketing. They need to be educated or made aware or trained to handle PII, PHI. Same goes for the finance, sales, and procurement. Procurement need to be trained how to write the contracts with privacy clauses. What are the privacy clauses that need to be included into the contracts? Are you with me? Are you understanding what I am saying?
Yes, sir.
Yes, sir.
Okay. Now, legitimate purpose of processing personal data. What is the legitimate purpose of processing personal data? You remember I gave you the example of ISP providing me internet connection. Correct?
Yes.
So he has written, I told you, there is a contract between Bilal and service provider. There was a contract. What was that contract? That I will give you the 5 GBP of internet per month at a rate of $50, and I will use your information in order to bill you per month. That was performance of contractual agreement. He has to this was the contract. He has to process my bills in order to fulfill the clauses in the contract. In the clauses, he is mentioning that he will process my PII to give me the bill. Then that processing is done in a legitimate manner. That is a legitimate purpose of processing. Are you understanding? This is very important. If you are not understanding, I can repeat. The very important concept of GDPR is legitimate purpose. What does that mean? What does that mean? Yes. Why am I processing PII, PHI? This is one. Is my processing legal? When an internet service provider is giving me services in the form of internet, we have signed a contract. He has signed a contract. in order to serve this contract, he has to process my PII. Because contract says what? That I will get internet services when I will pay him. I will pay him only when he will send me bills. He will invoice me. In order to invoice me, he has to use my first name, last name, my email address, and my phone number. Are you with me? So that serves as a legitimate purpose for processing. So the first thing is, what is the first reason of legitimate purpose processing? Performance of contractual agreement. This is one. What is the second one? Compliance with the legal obligation. Yes, compliance. Compliance with legal. What does that mean? That means this contractual agreement is legally liable. If he is not providing me the internet services, I can take that legal document and go to the court of law and they can penalize him. That means it is having a legal value. It is containing that, it is holding that legal weight. And this is a legal way of dealing business or of doing business between a customer and the entity, which is ISP. What is the third one? Fulfillment of legitimate interest. Legitimate interest. I as a customer I am getting the bills at the end of the month. So it is serving me, or it is giving me that legitimate interest to be in this contract, because I am availing the service and I am paying for it. If I am happy for the services, I am happy to pay. So it is serving the legitimate interest of both parties. He is earning money, I am availing the service. So legitimate interest of both the parties is getting fulfilled. In that case, that processing is following the legitimate purpose, when it is holding the principle of legitimate interest, when it is fulfilling this legitimate interest. Consent from the data subject. Consent from data subject. What does that mean? Processing will be legitimate if he has the consent from me that, okay, you can send me marketing and promotional emails. If this is the consent I gave ISP, then he can process my PII for sending me marketing emails, for sending me promotional emails. In that case, the processing becomes legitimate. Processing in case of public interest. This applies to the government entities. When the government is processing your PII or PHI in order to give you some benefit or in order to protect the public interest. protection of vital interest. What does that mean? In order to save some life, save a life, or in case of emergencies, if an entity is processing the PII, then in that case it becomes legitimate. Then the legitimate processing of PII, PHI is then the processing of PII, PHI in that case is said to be legitimate. If all the conditions are met from 1 to 6, then you can say that you are doing a legitimate processing of PII, PHI. Are you understanding this point? These are the basic conditions where you as a controller can say that I am doing the processing in a legitimate manner. I am doing the processing of PII, PHI in a legitimate manner, in a legal manner, When all these conditions from 1 to 6 are met, or any of the conditions from 1 to 6 are met. Now GDPR principles, very important slide, very important concept. Are there any questions?
Yeah, Bilal, I have one question. In terms of the processing of the data, okay, like one of the things that you mentioned about the recruitment, okay, and usually in certain in our department and all, once we collect the CV, okay, let's say this CV is not shortlisted, we used to retain those CVs in a database, in a one CV collection database. So in that case, one of the things you mentioned in the legitimate purpose is the
Sorry, your voice has broken.
can you hear me now?
Yes, yes.
Yeah. So at the time of collection of the CV, if the HR has obtained the consent from them that even though you are not shortlisted, that we will retain your CV for a certain period of time, so we can still retain it, so which serves the legitimate purpose, or so how does that work?
Yes, yes. In case I am having some there is some opening within the organization. Okay, there is an opening of the organization, and I am applying to that. Okay, I am applying to that in their job portal. Okay, in their job portal. In the job portal, they have to mention, first they have to inform me that we are collecting your personal information. Are you okay with that? They have to take my consent. Second thing, they have to mention that if you are not shortlisted, then we are going to retain your information. Retain your information for X amount of time. They have to mention this. And after this X amount of time is passed, then we are going to delete it. We will delete it. Sometimes organizations don't say that we will retain your information for a certain amount of time. They have a retention policy that once the purpose is being fulfilled, that means they have shortlisted candidates, they are going to delete it. They have to, they are very transparent because they have to maintain what? Maintain transparency, which is one of the principles of the GDPR. If they are going to retain it, they have to mention it here. I should be able to clearly see it in their privacy policy or in their privacy notice, or whatever information they want to reveal to the candidate. while applying for the opening. They have to be very transparent in that. If they are keeping it for X amount of time, they will mention it that we will keep it for X amount of time in our database, and after that time has passed, we will delete it. Or they are going to directly delete it after the the purpose limitation, or sorry, the legitimate purpose has been met. What is the legitimate purpose for collecting this information? Is recruitment. You are recruiting. That is your legitimate purpose. Once that legitimate purpose is fulfilled, you are either going to keep it for X amount of time, which you have to reveal to Bilal or the candidate, or you have to delete it.
Okay. Thank you, Bilal. So one more point over here. So now let's say we go obtain the consent, and now HR going to store this data in the CV database. So is there any specific rules or specific controls in the GDPR highlighting that while we are storing this data, any control has to be in place, like as you mentioned previously, data masking, encryption. So any specific things that they have to follow while they are storing the data?
Yes, I told you, one is the collection, one is the usage, you are storing it, you are sharing it, and you are deleting it.
Yeah, while storing, which control this regulation?
If you are storing it, you have to use encryption.
Okay.
You can use masking. Okay. You can use anonymization. You can use tokenization. Depending upon what type of data you are storing. If you are storing a PHI, then of course you need to encrypt it. And if you are using need to know and least privileges, you need to mask it, because internally, if you are processing it, internally, if the people are accessing the PHI, some people don't have access, or some people have only view access. So you need to mask it according to the role-based access control. Okay. So depending upon the use case, you are using different controls while storing that data.
Okay, thank you, Bilal. Thank you so much.
Okay, now the different principles of GDPR, it is very important that you understand these principles, because you will apply these principles at different stages of data lifecycle here. Okay, so here you are going to use different principles, and it is very important when you are implementing the GDPR. So first principle is accountability, lawfulness, and transparency. So you remember we have ABC Retail. ABC Retail has leadership, which is the CEO and the board of directors. This consists of their leadership. So they have given a commitment. They have given a commitment in the form of what? In the form of privacy policy. Privacy policy is what? Privacy policy is the commitment from the organization or from the leadership that we are going to do what? Since we are collecting the personal information and we are under the regulation of GDPR, it is our responsibility that we are going to secure this PII whenever we are collecting it. Okay, that commitment and that due care and due diligence, that leadership is maintaining, okay, during the course of or during the life cycle of GDPR is called accountability. So anything, any issue, any non-conformity, any mishap, any incident, any breach that is happening within the ABC retail, the ultimate accountability or responsibility goes to the higher management or the senior management. So they are accountable for it. They have to take actions so that they will not be penalized, they will not be sanctioned, they will not be having any incidents where they will be accountable or they will be liable for legal actions or for the fines by the GDPR. So they have to take this responsibility of safeguarding the PII/PHI. That process or that due care or responsibility which an organization is taking is called accountability. Lawfulness. We discussed about legitimate interest, right? There are different conditions that we discussed where an organization can say that they are lawful or they are legitimate while processing the PII/PHI. That lawfulness that you are processing the PII during a recruitment process. You are processing PII/PHI during a claim submission from a patient in case you are an insurance company. That processing you are doing in order to serve your customer is your legal basis or a lawful basis. Transparency. While collecting, processing, storing, sharing and deleting this information, you have to be transparent. You have to be transparent with the help of privacy policy or privacy notice. Privacy notice is meant for data subjects where they will be answered what information is collected, where it is collected, how it is collected, why it is collected, how long it will be kept with us, whom we are sharing it to, how we are sharing it, how we are deleting it, or when and how we are deleting. All these answers need to be given or need to be provided to the data subjects. That is called transparency. You have to give them the exact picture of entire life cycle of PII/PHI within your ecosystem and outside your ecosystem, meaning if you are sharing the PII/PHI with the third parties. What are your security measures? So all these things need to be transparently mentioned in privacy notice. This is principle number 1. Principle number 2, purpose limitation. Purpose limitation. You remember Bilal and ISP has exchanged the information. What was the information exchange? First name, last name, email, and postal address, and mobile number. Correct? This information was shared with ISP so that they can provide them internet services and I will be invoiced every month. This was mentioned in where? In the contract.
Agreement.
Correct? That is what is called purpose limitation, that my information, which is first name, last name, email, postal, and mobile, will be only used for billing purposes. Nothing else. No promotional emails, no marketing emails, no profiling, no sharing, no third-party processing. That is called purpose limitation. You will collect the PII, PHI only for the purpose for which you are using it. What is the third principle? Data minimization. Data minimization means he will not ask my maternal status. He will not ask my educational qualification. He will not ask my passport. He will not ask my Aadhaar card or social security number. Because they are not relevant to the service which I am getting or which I have to get, or it is not relevant to purpose limitation. When they are collecting more information that is needed for the processing, that means they are violating data minimization. They should minimize the data elements while collecting the PII, PHI. Controller has to minimize. That is what is called as data minimization. They have to minimize the data elements or the PII which is being collected. Accuracy. What does accuracy mean? That whatever PII, PHI they are collecting, they should maintain it accurately, or the integrity should be maintained. That means they should have those tools and techniques where they will maintain the accurate amount of data. Integrity and confidentiality all are called as cybersecurity controls. These are related to cybersecurity controls, which we mentioned as encryption, masking, multi-factor authentication, role-based access control, identity access management, physical security controls. All these controls will be maintaining the confidentiality and integrity. Storage limitation. Once the Bilal cancel the agreement or the contract, and I am going to another ISP, ISP2, who is charging me only $25 per month for the same amount of 2 Gbps. I am going to another ISP. Once this contract is cancelled, ISP1 should delete all my data. That is called storage limitation. They should have the retention policy, how long they are going to keep my data. Are there any questions? Is this understood?
Yes, it is.
If you have any questions, you can ask me, because I'm going to stop here. I will take the questions if you have any.
Yes, thank you, sir. I just wanted to know if you are processing data that involves European citizens. I'll give an example for my country, Uganda. And
Okay.
we have a data Privacy and Protection Act.
Okay.
Which one would take precedence, especially when there is like conflicting clauses? Thank you.
There are conflicting clauses between GDPR and your data protection regulation, the Uganda.
Exactly, yes.
Okay. So it depends upon the use case. For example, if you are processing European Union citizen data, then all those regulations or all those requirements which are coinciding or which are similar to GDPR, that will automatically apply because they will be common in your regulation also. If there is a contradiction that is between GDPR and your regulation, then in that case, the GDPR will superhead or it will be dominant to the processing of the European Union citizen. And you have to, divide the business processes, which is processing your European Union citizen data, and the business processes which are local to your, entity in Uganda. So you have to do that bifurcation and understand how your business processes is affected by the EU citizen PII PHI. Okay, and then apply GDPR principles on that. Whatever is similar, you will apply that. Whatever is contradictory, you have to apply GDPR requirements on that contradictory, or if there is a difference, then you will be applying the explicit principles of GDPR for those business processes or for those data PII PHI which is from European Union.
Thank you.
You're welcome. Any questions? Anything that you have not understood, and if you are having any questions, you can ask me.
Maybe just when it comes to storage limitation.
Okay. Yes, please. Hello.
Is there does sorry, my connection was a little bit breaking.
Yes, can you repeat your question?
Now, when it comes to storage limitation, is there a specified time frame for the entity to retain the data, or it's entirely about the retention policy for the entity, in this case the controller?
See, data retention is depending upon the business requirement of the entity. It also depends upon the laws which are applicable to that entity and how those laws wants you to delete the data, how long you can retain the data. For example, the labor law says that you have to retain the data of the employee for 7 years after he is terminated or if he has left the organization. So in that case, the employee data will be deleted after 7 years once he is left the organization. So it depends upon the legal laws, the labor laws, and the business process and the business requirement of the entity. Are there further questions? Are there any further questions? Okay, so I will conclude here. Tomorrow we will be meeting 8 o'clock, 8 p.m. Indian Standard Time. I will see you tomorrow. Have a nice evening. Thank you very much.
Good night, sir. Thank you. Thank you.
Thank you. Thank you. Good night.
Good.
Thank you.